All rise. First District Court of Appeals now in session. All that business before this court draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have one case scheduled for oral argument this morning, the case of Susan Siegel versus State of Florida Department of Corrections. Counsel, are you ready to proceed?
Yes, Your Honor.
You may approach, counsel.
Thank you, Your Honor.
Counsel, we allocated 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
I would say 10 and 5. We should, a break 10 and 5. Thank you, Your Honor. Gary Lee Printy on behalf of the appellant Susan Siegel. Today, the court has before it an order denying the appellant's petition for writ of mandamus, which was her attempt to get the Department of Corrections to comply with the direct language of her sentencing judge's order of restitution, which imposed restitution in the amount of $475,000 at that time. It's now been determined it's $468,000 in a pro rata basis. So the key thing here is when a judge entered this order stating it was to be distributed in a pro rata basis, what did that mean? For the DOC, that means, well, we'll get the numbers, we'll get the money, and we'll plug it into this computer, and it will tell us something that won't be pro rata, but it'll be pro rata as we determine it. Well, the order did not say.
You say it was pro rata as the department determined it. Was it just a completely arbitrary number, or do they have a definition?
They have some.
Do they have a definition of pro rata that you're aware of?
No. And if they had, then the judge would have said in a manner to be determined by the Department of Corrections. That's not what he said. He said in a pro rata basis. So you take these amounts, and here's why this is important. There's multiple defendants, but only 2 of them are involved in this manner, the appeal today. One of them is Ms. Siegel, who was ordered to pay $229,413 to Clement Park, a victim, and to Eastgate, a victim, in order to pay $238,645 to that entity. Michael Ramus, co-defendant who entered a plea with the identical plea documents the same day, he was required to pay that same $238,645 to Eastgate, but he was required to pay $278,195 to Clyde Truss.
I think we understand the directives, but for more specific questioning, I think what my understanding of the appellee's argument is it depends on the victim groups. So once you plug in this formula, and I appreciate both briefs, they did a great job. Both of you did a great job explaining math, which is sometimes hard to write about. But it seems to me their position is what we always do is it's per victim. So some victim groups may be bigger than other victim groups. And when we spread it out per payment by victim, you're going to have an unequal amount paid. But I think the counter argument from you in your reply brief that I want to hear about is recognizing COPS has 2 application methods. One, if the judge specifically says this is how I want it paid. And then 2, if it's an amount and then there's no specifics, then the system works it out. So is it your argument that in this case, the original judge's order assigns percentages that should control, in this case, over and above a random plug-in of the COPS system?
That's exactly it, Your Honor. He said on a pro rata basis. If you look up, pro rata is a term of legal art that means on an equivalent distribution. And he didn't address any other thing. That's what he said. So that's specific enough. He didn't say, like I said, in a manner to be determined by
So we're
them.
talking about the same word. It was a female judge that wrote the...
No, Your Honor. It was Judge Thomas Barber, who then later got appointed to the federal bench, was the initial judge. And that's kind of caused a problem here because I think, I only got into this case for the appeal, but I think my client, Ms. Siegel, has been arguing this pretty much, well, she had a lawyer and then she was doing it herself.
Yeah, I thought there was a judge subbed in for him, but I just want to make sure we're talking about the same order.
Judge Barber signed the order, and then he left, and now there's a Judge Laura Ward, who's the new judge, who's the successor judge on this case. She wasn't the judge who wrote the original order. If there had been, Judge Barber had still been sitting there, Ms. Siegel could have gone back to him and said, clarify your order. They're doing it this way. It's my understanding it should be this way. You, Judge, tell them and tell me what is the correct way to do it. Judge Ward had that opportunity but said, no, your relief, I'm going to address that. I'm going to say you should go to mandamus in Leon County and take care of that there. They'll tell you if you're right or wrong about that. But why this is also important is the victims of the Eastgate Company, those people are receiving and have received $54,000 less restitution that they would have received out of the payments that have been made. Mr. Ramos, his share of this was $54.46, $54 to Clyde Trails, $46 to Eastgate. He paid $341,000. If you do the math on that, that means $157,000 should go to one party, to Eastgate, and the rest to the Clyde Trail people. But instead, under DOC's formula, only $104,000 of his restitution has gone to Eastgate. Whereas,
Counsel, couldn't the court have said that when Ms. Siegel brought it to the attention of the Hillsborough County Court? Hey, the Department of Corrections is misallocating the restitution. They're not doing it in a percentage that Judge Barber ordered. They could have said, well, that's correct. Judge Barber meant pro rata to be between the defendants and not between the victims, and therefore their allocation is a violation of the sentencing order. Instead, they said, go talk to DOC. Go bring your claim to DOC. Doesn't that show that the Hillsborough County Court did not consider what DOC was doing to be a violation of the sentencing order?
Well, without saying that, no. It just means I don't know what I'm doing on this because I wasn't the original judge. You take that up to Tallahassee and you figure it out there. I think she could have and should have addressed it as I'm going to treat this as a motion for clarification and said what you just said, but she did not. She said,
what do we do with the circuit court's refusal to address the sentence order the way that your client wanted them to?
I don't know that it has any bearing at all. We're talking about whether Judge Lane Smith in Leon County could have said, I can read pro rata, and I know what it means, and here's what it means. She's right. We can't unring the bell of what they've done in the past. These poor Eastgate people are out there $50,000 that they would have got, but from henceforth, you will distribute it the way Judge Barber's original order of restitution says to do it. He said, no, because it's joint and several, doesn't matter, but it does matter because if, as it currently stands, if restitution isn't fully paid, the people of Eastgate are kind of getting screwed by this deal, by their deal, because there were, they want to look at it as Eastgate is comprised of X amount of individuals, Clyde's Trails of Clyde is X amount of individuals. We're doing it with all the individuals. Whereas, to me, the only way I think you can read it, since the judge, his order says pro rata, is Eastgate is going to get their percentage on an equivalency. Clyde Trail will get theirs. And however you divide up that number amongst those people is individual distribution.
Certainly, if we order or the circuit court ordered Mr. Ramos to pay more to the Eastgate victims, then it would mean less for the Clyde Trails victims then. So either way, the victims, there's only so much money to go around.
Well, but you're right. That's why it's on a percentage pro rata basis. It is what it is.
Counsel, you mentioned the key words was joint and several liability. That is, each defendant was held jointly and severally liable for the full amount. In view of that, what was the clearly established right of the appellant to require DOC to reapportion the pro rata share?
Well, she's acting because she thinks the people of Eastgate are losing out on this, and right now, she is also credited $54,000 less of what the amount she has to pay. Since they're both jointly and several for Eastgate only, you know, she has nothing to do with Clyde Trails, and Ramos has nothing to do with Clement Park. So looking at Eastgate, how are the people of Eastgate Solutions getting compensated? They're not. They're losing out because there's whatever number of people there are in Eastgate, it's being distributed, 104,000 is being paid to them at some pro rata thing. So if there's 50 people, it's 2,000 apiece, et cetera. It should have been 158, which means they would be getting $3,000 apiece instead of $2,000 apiece. And that's our argument, that that's the way it should have been, based on what the judge said. Because when you enter a plea agreement, because she paid $200,000 in inheritance from her father's death to put up $200,000 to enter into this plea. That was one of the conditions of the plea. Because you're putting up money, we're going to treat it this way. And then she finds out that even though this good faith effort by her to do something on behalf of these victims, she's not doing what she thought she was doing for these victims. Anyways.
You are into your rebuttal time.
Yes. Thank you, Your Honor.
Thank you, counsel.
May it please the court. My name is Maria Hossein, and I represent the appellee, the Florida Department of Corrections. We are here today because appellant was convicted of fraud along with her co-defendants, and now this person who defrauded hundreds of victims seeks to dictate to the Department of Corrections how her co-defendants' restitution payments should be distributed to the people they victimized, even though she has no clear legal right to do so. First of all, Ms. Siegel—
Assuming for the sake of argument that she does have a clearly legal right to do so, on the merits, how is appellant's expert's calculation on the apportionment or reapportionment incorrect?
Yes, Your Honor. It is a little bit complicated in this case because there are so many victims. But as the trial court judge's order said, each defendant was to pay restitution to the victims, joint and several, pro rata. As you can see in the judge's initial sentencing order, it does not tier the victims, so it does not say that some victims should be paid in priority over other victims. That is something that trial court judges are permitted to do. He did not do that in this case. While they are grouped into different categories based on, frankly, where their timeshares were located, that was just for an administrative purpose, probably to make it easier to identify the hundreds of victims that are at issue in this case. So because none of the victims were prioritized in the judge's order, when the Department of Corrections receives that sort of order, we treat all of the victims to be equal in terms of the priority in which they are paid. What that means is that when an offender makes a payment, each victim of that offender gets a proportionate share of that payment. That is the pro rata part of the judge's order. The joint and several points to the defendants and the fact that they are each responsible for the full restitution amount.
Couldn't that sort of be argued as a difference in pro rata application? So if you have an order that says 51% of the payment goes to X group, remainder goes to X group, some may argue, and certainly the simple, interpretation of that would be 51%, and then it's divided 46 or however much percent is divided the other way. So are you not arguably ignoring that pro rata assignment by then incorporating into it an each individual victim component, which then pretty much dissolves the pro rata percentage assigned by the judge?
I understand what you're saying, Your Honor, but in the judge's order, he explicitly stated how much each individual victim should be receiving. And as you can see in the order, the victims are all eligible to receive a specific different amount of restitution. He did not treat it as this entire group should receive this amount of money and each victim should receive an equal amount of the money. Some of the victims are owed $4,430. Some are owed $1,100 approximately. So what happens is when the department receives a restitution payment, the victims that are owed more as their outstanding balance will receive a larger proportionate share of that payment. So for example,
Yeah, but
if one victim...
of the pro rata assignment, so you break the payment down into amounts, then they're distributed
Exactly,
per
Your Honor.
group.
Not per group, Your Honor, per victim. So the victims amongst any group, so for example, Offender Siegel has 2 groups, but when she makes a payment, victims in both of those groups get a proportionate share of her payment. So if one
Then
victim is owed...
Each defendant in the proceedings below share the same victims.
Not each defendant, Your Honor. It's a little bit complicated. So Offender Siegel and Offender Ramos do share one victim group, and then Offender Siegel has a separate victim group with another co-defendant who we haven't mentioned today, and Offender Ramos has a third victim group with another co-defendant that we haven't mentioned today. So when one of them makes a payment, that payment is going to some of the victims in their shared group and also to some of the victims in a group that they do not share with the other co-defendant. So, like I was saying, if one of the victims is owed, let's say, $1,000 and another victim is owed $100, when an offender makes a payment, the victim that's owed $1,000 will receive a larger share of that payment as opposed to the victim that's owed $100. So then once those balances are recalculated, the next time somebody makes a payment, it might be that that person who was owed $1,000 is now getting a smaller percentage of the next person's payment because they don't have that much money outstanding anymore.
Is there a civil remedy? Say, all the victims are paid, regardless of the pro rata argument. At the end of the day, all the victims are paid. Is there a civil remedy that's available for these co-defendants to work this out separately after all victims are paid?
Yes, Your Honor. The department would argue that there is an alternative remedy, such as that it exists frequently in tort cases where one tortfeasor will go to a civil court and try and collect an amount of the restitution they've paid from their other tortfeasor. So the Department of Corrections would argue that Offender Siegel could take Mr. Ramos to a civil case to attempt to collect some of the money if she feels that she did not pay her fair share. But again,
Counsel,
since they're
the
both...
fact that the defendants were held jointly and so reliable for the proceeds, how could one defendant have a cause of action against another defendant in a civil proceeding?
Yes, Your Honor. That is the Department of Corrections' entire point. Since they are joint and severally liable, the Offender Siegel is responsible for 100% of the restitution amount that was ordered to be paid. So she does not have standing even to bring this today because she has not been injured unless she is paid at least 1 penny more than the restitution ordered by the court. It is a benefit, of course, that Offender Ramos makes payments towards their joint group, but that is just a benefit. It's not a right. Offender Siegel is responsible for 100% of the payment. So whether that means that she gets to pay a little bit less because Offender Ramos made a payment, or maybe in an alternative universe he didn't make any of the payment, she still would have to pay 100% of that restitution amount.
Would it be appropriate if you assigned 100% of Ramos's payments to the Clyde Trails defendants, all of it, and just said, well, Ms. Siegel can handle the Eastgate defendants. We're just going to go ahead and assign 100% to Clyde Trails?
Well, my answer is twofold, Your Honor. One is that the department is attempting to comply with the trial judge's order, which says that the victim should be paid pro rata, meaning they should each get their own proportionate share. But it's the department's opinion that if we were to allocate one offender's payments all towards one victim group, that would just be re-victimizing the other victim group. There's nothing in the judge's order that said that one victim group is more important than another one, and that's just Offender Siegel's opinion that, of course, she would like her victims to be paid off before Offender Ramos's. But that's not fair to the victims. The whole point of joint several restitution is to put the risk on the offenders and to make the victims whole through this restitution. And so by paying off a different victim group first, the shared victim group would be being re-victimized, essentially.
But my suggestion, would it be permitted because the liability was joint and several? Would it be permissible?
Well, Your Honor, I believe the joint and several points more to the fact that each offender is responsible for the full amount of their victim group, and that is of their victims, and that is why the department is paying distributing these restitution payments equally towards all the victims. I don't think the victim groups really matter. They were just administrative purposes by the trial judge. Again, because if they did matter, he would have what's called tiered them and would have said that one victim group is more important than the other. If the Department of Corrections were to do as Offender Siegel wanted and prioritize one victim group, we would not be complying with the judge's order. Additionally, Offender Siegel can point to no clear legal right that says that the distribution of payments should be the way that she desires. And as you know, that is one of the elements of a petition for writ of mandamus, and she hasn't been able to point to anything that says that the department is not distributing the payments in the way that the judge has ordered. Additionally, to the extent she's trying to establish a clear legal right, the case of Florida Caucus of Black State Legislatures versus Crosby has said that that is not an acceptable way for a petition of writ of mandamus to be granted. What Offender Siegel is actually seeking is prospective injunctive relief, which again is not appropriate for a petition of writ of mandamus. In that case, the court would have to continuously and constantly monitor how the department was distributing every single one of these payments monthly to all of these victims.
Counsel, let's assume for the sake of argument that the defendant's expert was correct in his calculations in terms of the pro rata share. What remedy, if any, would the defendant have against the department?
I cannot think of a clear legal right that the defendant would have in order to essentially sue the Department of Corrections for distribution of these restitution payments. As in Florida Statute 775.089, the court can order the Department of Corrections to collect and distribute restitution payments as per the court's order, and that is what we are doing. As we said earlier, she might have a civil suit against her co-defendant, Mr. Ramos, if she would like to try and pursue that course of action, but she does not have a right to sue the Department of Corrections for how we are distributing the payments, especially since they are in alignment with the judge's order below. Additionally, it's important to note that once again, when we were talking about joint and several and pro rata, which are the two phrases that the judge used in the order below, we can't read joint and several and pro rata to both be about the defendants or the victims. It has to be that joint and several is indicating the defendant's responsibility and pro rata is indicating the amounts that are owed to the victims, because joint and several means that they are each responsible for 100% of the restitution amount, whereas pro rata means your proportionate share. So those can't be read together. That would be like reading joint and several and comparative negligence together, for example. Those terms are conflicting. So it has to be that the joint and several goes towards the defendants and their responsibility for paying 100% of the payments to the victims. And pro rata means that the department should be giving the payments to the victims in the specific amounts that the judge said that each victim is owed in his sentencing order.
And speaking of conflicts and potential conflicts, in studying the COPS application and looking at the formulas that you use, I noticed that as a denominator, there's a factor of total months of payment required before probation ends. So if that's a fluctuating component based on where a defendant is in their restitution payment, affecting whether probation continues or not, wouldn't the application in this circumstance implicate constitutional issues? It hasn't been raised in these briefs because obviously it maybe is not yet right, but isn't that a conflict that arises with the DOC application?
Your Honor, despite what opposing counsel was arguing, the COP system is not some sort of arbitrary system that's assigning random numbers about how these victims should be being paid. Instead, as you mentioned, one of the factors is how many months that an offender has left on probation and how the payment should be divided based on that number of months. As you know, an offender can't get off of probation until they've completed their restitution payments, and so that calculation is just based on the number of months they have left on probation and the minimum monthly amount that they would have to pay in order to fully have paid off their restitution prior to the conclusion of their probation so that those two goals can align, the payment of all the restitution and the date that the offender should be finishing his probation. And so that is one of the factors that's in the COP system. And then the other factor is, like I said, the outstanding balance that is owed to each victim. And so those balances are manually adjusted each time that an offender makes a payment to a victim. Because, of course, if a victim's owed $1,000 and then they get $200, well, they're no longer owed $1,000. Now they're owed $800. So those balances change, and therefore the percentages of the payments that each victim gets changes each time an offender makes a payment as well. So those percentages that Mr. Prinny was pointing out, his numbers are based on the original court order and the percentages of the full groups in the original court order. But those percentages change based on the payments that Ms. Siegel makes and the payments that Mr. Ramos makes. And because of that, those percentages that are going to each victim are always fluctuating and are fluid. So there might be one month, such as the month that his expert did the analysis, I believe that was in February, that was in July 2021. Those were the percentages that he used at that period of time, and he based them off of the original court order. But as you can see in the record on pages 510 and 514, for example, those are showing numbers from February 2022, which are different from the original court order, as I said, because the numbers fluctuate based on the payments and how many payments have been made to a specific victim that these offenders might share or might not share. If there are no further questions, the appellee respectfully requests this court to deny the petition for writ of mandamus. Thank you.
Thank you, counsel.
Your Honors, there seems to be, they're in love with their program. I get that. But they keep saying that there would be, if the people of Eastgate got the money, 46% of everything Mr. Ramos paid. That's the number. 46% of everything Mr. Ramos paid should go to Eastgate on a pro rata basis. They're not getting that. They're losing out. And Ms. Siegel's only required to pay $40 a month for the rest of this probation. So obviously, people aren't going to get paid. It's only the people of Eastgate who are really getting the raw deal because they're $54,000 behind. So if anybody was victimized, it's the Eastgate people, and the Clyde Trails people are being rewarded for something. They're getting more money than Clyde Trails group was victimized. They were victimized to the tune of 54%. Eastgate was victimized by Mr. Ramos to the tune of 46%. They're not getting 46%. They're getting less than that, $54,000 less. And that also means that at the end of 10 years, if Ms. Siegel had the wherewithal to write the balance and pay the whole thing due, it would be $54,000 more than it should have been. Not because that's what the judge wanted, but because that's what DOC's program does. And if the judge wanted to do it that way, that should have been it, in a manner determined by the Department of Corrections. Very simple, clear language. You pay the money, and they'll figure out what to do with it. He gave them directions, pro rata. That's what that means. Otherwise, it has no meaning at all. Just get the money and pay it to somebody, whoever you think best. And that's not what he wanted to do, apparently, because he could have said that too. DOC, you get to be God on this one, and you just pay out the money however you want. And those people will never get their money, because even if you grant this mandamus, they're not going to get it back. Now, I suppose they would have an action against DOC, you could say, for not following this judge's order. By not following the judge's order, you cheated us out of $54,000, and we want it. So DOC, you pay us, because it was your computer program that cheated us, not the payment by Ramos and Siegel, but their program. So that's where we are. Thank you, Ron.
And thank you, councils, for your respective oral arguments this morning. We are adjourned.
All rise.